Now, in what could be a win for free speech, the Supreme Court struck down federal rules which may prevent immoral or scandalous material from getting trademark protection. Now, the 6-3 decision comes from a case in which a clothing line with the name FUCT was in a trademark dispute over the obvious similarity of its name and another four-letter word. However, Chief Justice John Roberts, in his dissent, said, "The First Amendment does not require the government to give aid and comfort to those using obscene, vulgar, and profane modes of expression." So for more on what this means for speech in the First Amendment, we turn to legal and media analyst Lionel. Lionel, thank you for joining us on this. I mean, if you know First Amendment, I'm not saying you would know vulgar words, but in this case, I'm going to lean on your legal expertise, and we're going to use some more. We're going to figure out exactly what is the breakdown in this and how it actually affects things like hate speech today.
Well, first of all, this is a great day for freedom of speech. Great day for the court was able to say that we're not going to discuss whether this particular word was immoral or scandalous, whatever. However, what they focused on was that the way the government decided this was based upon a viewpoint analysis. It was, what is your point of view? If Alito said very frankly, if you want to have a law that says you cannot have the F word or variations, fine, that's one thing. But what the court said was you allow some things in and some things don't. Remember, Scottie, in 2017, there was a case of an Asian rock group that wanted to trademark the name of its group using a phrase which was considered by some to be pejorious, or actually, I should say, problematic and disparaging to Asian Americans. The court said it is unlawful to violate somebody or to have a law that says you can say things that are beneficial to a group but not disparaging. Again, they focus on this thing called viewpoint prohibition. Not so much the words, but why we allow this but not that. That's the critical point.
Well, and that's the thing, Lionel. Was this actually a case about indecency or obscenities being spoken or put on a label?
Absolutely not. That's what brought you in.
Right.
That's what brought you in. But for example, they went through and they said that if somebody were to use a case of marijuana is great, the THC is great for such and such, that's verboten. But just say no to drugs is okay. Again, the court said, it's not the fact that you talked about drugs. It's not the fact that you talked about illegal drugs. It's the fact that you okayed prohibition here versus advocacy here. That, again, is viewpoint. It's not that you have a law that says, can't mention drugs. That might be even considered more draconian. They might have been able to handle that as well. But the government should not be able to say, we like this particular message and not this, even with something as mundane, one would think, as copyrights and trademarks and intellectual property. This is a great day.
And Lionel, that's the thing. This is about the bigger picture. It's not usually, and if it gets to the Supreme Court, it's usually not directly, it might be about the case involved, but it's actually a bigger picture and how that's going to impact other companies going forward and the freedom of speech.
Precisely.
Exactly. And here's what's so funny. The dissenters were an interesting trio, were they not?
Yes, you have a group, you have the reasons for this, which I thought were interesting, was not necessarily that they were against, how do I say this? Not that they weren't against the reasons, but they're saying, doesn't the government have the right to do this? And it's hair splitting. You know, remember, let's go back a while back. Remember the classic case about Pacifica, the 7 dirty words.
Right.
People think that somehow the Supreme Court sat back and said, all right, what about this? Okay, that's dirty. What about you? Potter Stewart. Oh, that's a good one. They didn't sit down and write these words down. They asked a very simple question. Can the government limit this type of speech? And they said, yes, they can. But what they did here was, rather than just stick with that, they said, but let's go a little bit deeper. Why is it? This isn't just a blanket prohibition. This is what I want everybody to understand. Blanket prohibitions, believe it or not, are okay. It's when Scottie can say this if she advocates, let's say, motherhood or the American flag, but Scottie can't say this if the same person advocates, let's say, disparaging the government or some type of a tyrannical messaging That's when they said, wait a minute, the government cannot pick and choose which particular viewpoint is acceptable. That's what it stands for.
Well, it's kind of like beauty. It's in the eye of the beholder, and I think you're beautiful, and that's not something I need to go to the Supreme Court and debate. Thank you so much for joining us.
Bless your heart. Thank you so much.
That's also not a compliment to Southern women, by the way. So that's a different
or
entendre.
Southern men.
Okay, well, there you go.
Or Southern men, indeed.
And
thank you so much.
Thank you for joining us.
Hey YouTube, thanks for checking out our channel. We hope you enjoyed the video. We have tons of content for you just like this. For more of RT America's one-of-a-kind news and analysis, be sure to subscribe and never stop questioning more.